How should that influence our understanding, though, of conservatives and a lot of libertarians usually have a negative view on judicial activism? How should the 9th and 10th Amendment, as originally understood, affect our view of that term? Obviously, there's a difference between bad judicial activism and good judicial activism. I worked under Clint Bullock, and he is one of the few. He started IJ, and he's one of the few libertarians. He's a big fan of judicial activism, and he gave me some interesting. He planted some interesting seeds in my mind, and I was curious to see what you would think about that.
Sure. Judicial activism, that's the thing which judges should not do. Okay. We know that. But actually pinning down the term sometimes can be difficult. Presumably it means something more than judges shouldn't render opinions I don't like. I mean, hopefully there's a little bit more content to judicial activism. But really it's used in different ways at different times. I think the closest consensus view of judicial activism involves the court striking down a law passed by the people's representatives. That is judicial activism, as opposed to judicial deference, where the court upholds or allows to go forward a law passed by the federal or the state governments. Okay. For a long time during the 20th century, there was a certain area of constitutional scholarship and judicial thinking that believed in deference. You should not be active in striking things down except when really there's an emergency. Most times you should actually defer to the political process. That's an idea that actually came along with the New Deal. Stop striking things down. Let the federal government do what it needs to do for the good of the people. Judicial activism also became a big part of political rhetoric during the 60s and 70s when the court is striking down local criminal procedure mechanisms, striking down local practices that don't fit with the regime of Miranda and other criminal procedure rights. So anyhow, let's just take this as a definition. Judicial activism means striking down instead of deferring to. Okay. Well, if you have a particular constitutional theory that believes the people are best, the will of the people is best expressed through representative government, for example, the UK, for example, England, you're going to be opposed to judicial activism. You're going to be in favor of deference, and you're going to hate what I just put up on the board. Because what I put up on the board suggests that the court should be enforcing the 9th and 10th Amendments just like it enforces the rest of the Bill of Rights, and that means occasionally being active and striking down at least federal power. And that's where this presentation is focused at the federal government. On the other hand, the traditional American constitutional approach has always been judicial activism is justified when the court is enforcing the will of the people against mere majoritarian government. This is the whole purpose of a Bill of Rights, as Jackson wrote in West Virginia Board of Education against Barnett. The whole purpose of a Bill of Rights is to remove certain subjects from the vicissitudes of political discussion. Some things, some rights depend upon no vote, that kind of thing. I would agree with Madison that it's that latter conception which is correct. Sometimes the court should be activist. Judicial activism should play a role in striking down efforts by the federal government to enact laws that are none of the federal government's business, but were meant to be left to local self-control. Libertarians would go even further. A libertarian view of the 9th and 10th Amendment would say, not only should we be striking down federal laws, we should be striking down state laws too. Right? That's not the vision that I think Madison and the originators of these provisions wanted. They wanted to leave some matters to local self-government. So this is really a provision that I would say the court should be activist in regards to the federal government and leave a lot of these matters, like education, for example, to local self-control. So I would be, in sum, a long answer to a short question. I think the founders envisioned activism in furtherance of federal separation of powers, and I think that's right. And I'm also convinced about that in terms of normative reasons too, that we could talk about.
Well, that helps because that's a big debate right now. All these little libertarian, conservative legal clinics are popping up all over the country and doing great work in one sense, but those are things that I'm struggling with.
And they're doing terrible work if you have a different view of the Constitution,
sure,
where you think it should be left to representative government. So again, it depends upon your theory. Yeah.
You beginning to touch on it as you're winding up the answer, but in terms of Griswold, where he's finding kind of this right to privacy, is it almost, if you're assuming that it's the goal of the judiciary to strike down state laws that interfere with those rights found in the Constitution, is that a kind of correct version or interpretation of the 9th Amendment as you're laying out?
No, at least not in terms of you're going according to the original understanding of the 9th Amendment. It actually, and Black even recognized this in Griswold itself, it turns the 9th Amendment on its head. Because here's what Goldberg and the majority did in Griswold. We think that the 9th Amendment protects individual liberties against the policy decisions of state and local government. And state and local government adopted this anti-contraceptive law back in the turn of the century, but they adopted it. So according to Goldberg, we should strike down state law because it abridges liberty. The vision of the 9th Amendment that I think Madison and the founders had in mind is that maybe you could strike down a federal anti-contraceptive law. That's none of your business, federal government. You're supposed to be protecting us, you know, from the invading French, or the invading English, or then the invading French, and then the invading English. You're supposed to be taking care of that kind of stuff. But these kind of local moral matters, those have always been understood to be matters of local communities, and they differ. Virginia's different from Massachusetts. Massachusetts is different from Florida. Each one of these local communities should be allowed to decide for themselves what their majority policy is going to be in terms of contraception, right? So the 9th Amendment would suggest that Connecticut can pass any kind of law regulating medicine that it wants to, free from federal interference, whether it's the federal government or the federal courts, right? So it would have been correct to strike down a federal anti-contraceptive law, but he should have upheld the state's, Connecticut's right to decide this for itself, even if it was an extraordinarily silly law, as the court sometimes says. Yeah, please.
That's absolutely true in Madison and Randolph's time. But the 1868 changed things, I think, just a little bit. The 14th Amendment...
Did something happen then? What happened at that
Something
point?
happened in 1868 that it seems to me said, for the first time,
Yes.
that our Constitution means that the federal judiciary is to be in the business of striking down state statutes and local ordinances that interfere with your 9th Amendment rights that have been reserved to you. So they're reserved to you now, not only from the federal government, but also from state and local governments.
The premise behind that, and a very important point. The premise behind what I'm discussing, I haven't talked about it too much, but the premise, and really it's a premise that's shared, I think, by every member of the current court, is that what you're supposed to be doing in interpreting the Constitution is interpreting what the people have placed in the Constitution, right? There are debates over what they put in there, right? You can have different interpretations, but that's what we're trying to do. Okay, I told a story about what the people did at the time of the founding, right? But the premise of the Constitution is that those aren't the only people who count. The people reserve the right, the revolutionary right, to alter or abolish their forms of government as they see fit. That's the Declaration of Independence. It becomes Article 5. Article 5 allows you to amend the Constitution if you decide, I don't know, maybe slavery is not really such a great idea. We have a discussion during the first decades of the Constitution over how much freedom we want to leave to state majorities to control individual liberty. Whether or not slavery is a matter that the country can live with, that it erupts into a civil war. The settlement after the Civil War, states lose. We reconfigure, we the people, reconfigure the distribution of power between state and federal governments. You get the 13th Amendment, no more slavery, whether states like it or not. 14th Amendment, privileges or immunities, due process, equal protection. 15th Amendment, male African-American vote. All of these take powers away from the states that would have been reserved to the states under my theory of the 9th and 10th Amendment. What I've talked about in my work, and which I'll just briefly talk about here, is that I completely agree with that story. That the 14th Amendment in particular took things away from the state government that had been reserved to the states under the 9th and 10th Amendment. But, I would argue, it didn't take everything. Okay. In the beginning, at the time of the founding, yes, you would have certain rights retained by the people on a state level. Then you get to the 14th Amendment, that's exactly right.